If your lawyer asks you to do classes, anger management, alcohol treatment, a victims panel, should you do it? Is that an admission of guilt? Well, if you're interested in this subject or you're charged with a crime, stay tuned because this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes for more than 20 years. And I'm putting out these videos to educate the public because let's face it, there's not a lot out there. So if you find this video useful, please like and please subscribe. More people will get the information they need. Now just jumping right into it. If you do some classes for your criminal case, is that an admission of guilt? I mean, it seems like it, right? Let's say you're charged with assault and your defense attorney wants you to do an anger management class. Well, aren't you admitting you have an anger management problem? Can the prosecutor use that against you? Same way, let's say you get charged with a DUI and your attorney wants you to go get an alcohol evaluation and wants you to do treatment. Well, isn't that admitting you have an alcohol problem? Can the prosecutor use that against you to show, hey, if the defendant is doing alcohol treatment, they must have been drunk because otherwise, why would they be doing treatment? Well, that makes sense that you might think that, but the rules of evidence say otherwise, that is not going to be admissible in a criminal trial against you or against a defendant. And that's because of public policy. In civil matters, the rules of evidence can also apply, and there's a common one that says like offers of settlement aren't admissible to show liability, and also fixing products after the fact generally is not admissible to show liability because the public policy says we want to fix things that are broken. We don't want to stop people from fixing things that are broken to try to protect themselves legally because the public will suffer. And you can sort of think about that in the same way in a criminal matter. So the civil matter might be a products liability case, right? Hey, this product was defective, and if the manufacturer fixed it, if the fact they fixed it could be used against them, they would never fix it. Think about it the same way in your criminal case. If you do an anger management class to try to help show the prosecutor you're reasonable, the prosecutor cannot then go use that with a jury and say, hey, defendant did anger management class, therefore they must have an anger problem. That would not be admissible, and a prosecutor most likely wouldn't even try that because it's so clear under the evidence rules. The same thing goes if you do alcohol treatment. Hey, jury, look, the defendant did 6 months of alcohol treatment. They must be a drunk, and therefore they must have had too much to drink when they were driving. Again, that will not be admissible. If that was tried to be admitted into evidence, your defense attorney would object. And while I'm not 100% certain, I'm as close as you can be, that would be sustained and that would not get into evidence. So I hope that puts that part of your mind at ease. If your attorney wants you to do some classes, it is not an admission of guilt. In fact, it's a really good idea. You may have seen some of our other videos talking about criminal defense, but one of the biggest theories of criminal defense, at least that our firm uses, is we want to have the client do something so the prosecutor can feel they've responded to your case in some way besides having to try to convict you, right? Everybody is self-interested. The prosecutor has a job to do, and their job is supposed to do justice, but that may not be exactly how prosecutors think about it. Again, they're self-interested. They need to respond to your case. And so if you do nothing to educate yourself, nothing to help yourself, the prosecutor is going to be less likely to listen to what your defense attorney has to say about what's wrong with the case, the factual problems, etc. It's human nature, because I hate to say it, criminal defense has a lot of human nature, a lot of game theory involved, things like that really can affect outcomes. And let's face it, you want the best outcome with the least amount of risk, right? So if you've done something, you've done a class, you've gotten some treatment, now the prosecutor can relax. Hey, I've been part of some response to this case. Now I'm more willing to listen to what the defense has to say about the other problems with the case or how great the defendant is, things like that. So Doing classes, only do the ones your attorney suggests, because some classes are worthless. They won't be accepted by the court, certain online things like that. But if you do what your attorney asks, you'll have a better chance of them being able to help you. And a little side note, if you're doing classes, things like that, make sure your agency only sends the proof of completion to your attorney. You don't want the prosecutor or the judge to be getting things that the defense attorney hasn't decided it's the right time for them to get proof of what it is you've done. It does make a difference. So to summarize, doing classes, treatment, things after the fact cannot be used against you in your criminal case. There can be exceptions. I can't officially give legal advice here, but that's my experience in 30 years almost of doing this. And usually speaking, it's a very good idea to do some classes, to not let the crisis go wasted, to do some stuff so the prosecutor and even the judge are more able to hear your side of the story later. It's human nature. So again, if you found this helpful, please like and please subscribe. And more importantly, if you're in a situation with a crime or someone you know needs help, feel free to give my office a call. Again, I'm Lance Fryrear. We have a law firm in Linwood, Washington. We've been handling this type of thing for more than 20 years. If you're in trouble, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.